Hello everyone, welcome to CAshcroftTV. My name is Ashcroft. Thank you very much for watching this video on Guide to Legal History and Historians, where we will be covering all of the chapters from the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tommins. Today we will be covering Redeeming the American Foundings by Norman W. Spaulding and Foundings, European Integration by Peter Lindseth. So once again, I think it's sort of a perfection of chance in that we're comparing essentially American and European legal history in one episode, so at least it was a pleasant surprise that they came together. I know that the United States is only one country, and Europe includes many countries, but in terms of perhaps economy or perhaps in terms of population, they actually might actually be quite comparable, at least in those metrics. But nonetheless, this video will be done in the style of Plutarch's Lives, so we will have a brief biography of Norman W. Spaulding and Peter Lindseth, and following their two respective chapters, we will also have a comparison of the two authors as to hopefully learn a little bit more about them both and both of their respective works. So without further ado, we will begin with Redeeming the American Founding by Norman W. Spaulding. So, in terms of a brief biography of Norman W. Spaulding, he is the Nelson Bowman Schweitzer and Marie W. Schweitzer Professor of Law at Stanford Law School in California in the United States. His expertise includes civil procedure and litigation, complex litigation, ethics and professional responsibility, federal courts and federal jurisdiction, and legal history. He concentrates on the American legal profession and adjudication, and in 2014 he won the John Bingham Hulbert Award for Excellence in Teaching. In 2010 he served as the Covington and Burlington Distinguished Visiting Professor of Law at Harvard Law School, and in 2004 the Association of American Law School presented him with Outstanding Scholarly Paper Prize for his essay Constitution as Counter-Monument, Federalism, Reconstruction, and the Problem of Collective Money, published by the Columbia University Law Review. He's a member of the American Law Institute and the American Bar Association Standing Committee on Ethics and Professional Responsibility. Before joining Stanford Law School in 2005, he was a professor of law at the UC Berkeley School of Law, and also in California. And before that, he was an associate at Skadden, Arps, Slate, Meaghan, and Flom LLP, where he practiced environmental litigation. He also served as a law clerk to Judge Betty B. Fletcher, who graduated from Stanford as well in 1943, apparently. Or that cannot be right. Stanford Bachelor of Arts, nonetheless. As well, he clerked for the U.S. Court of Appeals Ninth Circuit, which covers the District of Alaska, Arizona, Central, Eastern, Northern, and Southern California, Hawaii, Idaho, Montana, Nevada, Oregon, and Eastern and Western Washington. He also clerked for Judge Thelton Henderson of the U.S. District Court of Northern District of California. He received his Bachelor of Arts, magna cum laude, from Williams College in 1993, and his Juris Doctor from Stanford Law School in 1997. His publications include Civil Procedure, Cases and Problems, 7th edition, as well as the previous editions as well, which he wrote with Babcock B., Massaro T.M., and Giles M., and is published by Walzer Kluwer in 2021, as well as another article, Online Dispute Resolution and the End of Adversarial Justice, published in Legal Tech and the Future of Civil Justice, published by the Cambridge University Press in 2023. And a third article, Is Human Judgment Necessary? Artificial Intelligence, Algorithmic Governance, and the Law, published in the Oxford Handbook of Ethics of AI, published by the Oxford University Press in 2020. So another affiliation with the Oxford Handbooks. So his chapter in the Oxford Handbook of Legal History is in part 5, titled Illustrations Doing Things with Legal History. It is chapter 53 of the textbook, and it is titled Redeeming the American Founding. So starting off with the chapter itself. So he's there are it mentions here that in an asterisk, thoughtful alternative accounts of redemption in American legal thought can be found in Amy Kapczynski's Historicism, Progress, and Redemptive Constitution, published in 2005, published in the 26th Cardozo Law Review, 1041, and it's drawing on Walter Benjamin's concepts of redemption, as well as J. M. Balkin's Constitutional Redemption, Political Fate in an Unjust World, published in 2011, and this chapter develops a more skeptical claim about redemptivism. So that is sort of the approach of this chapter. So he opens up with two quotes, the first being from Frederick Douglass in 4th of July in 1852, and the quote goes as follows: "This 4th of July is yours, not mine." The second quote he opens up with goes like this: "The end to be attained justifies the means. We are willing to believe, but the sight of these pictures is a commentary on civilization, such as a savage might well triumph to show its missionaries. Yet through such martyrdom must come our redemption. War is the surgery of crime. Bad as it is in itself, it is always implies that something worse has gone before. Where is the American worthy of his privileges who does not now recognize the fact, if never until now, that the disease of our nation was organic, not functional, calling for the knife, and not for washes and anodyne?" And this is a quote by Oliver Wendell Holmes, Sr., in July of 1863. And this will detail this much further as we follow. So the author notes starting with section 1, that although they're separated by more than a decade, these two quotes, the remarks of Holmes and Douglass address the same subject, which is the American founding, whereas Douglass indicts, Holmes convicts. According to the author, Douglass's use of the second person plural pronoun throughout the first part of the speech, "What to the slave is the 4th of July," that is the title of the speech, merges all the traditional elements of indictment, caption, commencement statement, and conclusion into a single word, "yours," according to the author. "What have I or those I represent have to do with your national independence?" is another quote from the same speech. Pardon me. And then there's a quote as well from Caesar Starter, from "Freedom is with no less than 11 relatives," mirrored the sentiment when he argued in the Essex Journal of the Merrimack Packet, an essay on slavery, weeks before the First Continental Congress would convene in 1774, in opposition to the intolerable acts passed by the British Parliament for the Boston Tea Party. Wrote, "The absurdity to end political slavery while you still have slaves in your home." So that's quite an indicting phrase, too, by Caesar Starter. So this metaphor of political slavery was not Starter's only. It belonged most prominently to Locke, who in the second treatise on government, that's John Locke, sought to justify resistance and revolution against tyranny by characterizing legislation contrary to the natural rights of people as enslavement, following state of war against the people. So this political slavery. So they sort of, starting with Locke, see this sort of gap in that one might be able to get rid of slavery on paper, but there is still slavery, political slavery, under perhaps the British government in the American context during its founding. There's also the metaphor is used by the opposition Whigs, who remained salient through the debates on the ratification on the Constitution more than a decade later. Americans thus were acutely aware of the basic contradiction named by Douglass in this disjunctive grammar of Independence Day oration, not only before the founding of the Republic, but in and through it. So there was this sort of recognition of, for example, slavery, both before and after the founding of the Republic. Holmes's statement on the American Civil War and the crime of slavery was drawn from an essay on new science of photography, and it describes a series of pictures taken by Alexander Gardner of fallen soldiers about the battlefield of Antietam in September of 1863. More than twice as many Americans, 25,000, were killed in a single day than in every other 19th century American war combined. So I actually, before reading this chapter, I did not know about this Antietam, but it is the most significant, by a long shot, the most significant place of bloodshed. But it must be noted that perhaps the bloodshed is higher because they were all within the bounds of the U.S. So, for example, during World War II, when they went to, for example, D-Day, for example, or something like that, half those dead, or maybe even more, were from a different nation. So within a civil war, of course, the death cap of Americans will be larger, but nonetheless, to be a bit greater than all the others combined in the 19th century is very significant. Before this, as Richard Slotkin observed, it was still possible for Americans to imagine a compromise settlement of sectional differences. So before this, Antietam marked a turning point, or a pivot point in the American Civil War, where it inevitably came to violence and there wasn't really a settlement. And Lincoln before had welcomed such a settlement to preserve the Union, even if it meant preserving slavery. After Antietam, however, Lincoln's pivotal decision to use victory to announce the Emancipation Proclamation, the only way the war could end was the outright victory of one side over the other. So after this huge bloodshed debate, Lincoln sort of took a pivot and thought that it had to be achieved through war or bloodshed. And it became a war of subjugation aimed at destroying the South's ability to resist and uprooting its fundamental institution. This caused both Lincoln and Davis to stretch their constitutional authority to or beyond the breaking point. At the time, in autumn and the early winter of 1862, the North remained demoralized. Antietam was in Maryland, the Union territory, and Lee, before was being pushed back, had already come so close to Washington, D.C. So this battle took place in the North. So it probably going into the war, it didn't look like it was such a great thing, and General Lee had gotten so close to D.C. However, the North won, and then sort of retroactively justified it. Such high casualties that many Northerners saw as a suicide mission, and suspicion that Northern lives were being wasted because of mismanagement and political meddling. Nor was there great enthusiasm for the Emancipation Proclamation in the mainstream Republican circles as well. The Northern Democratic opposition was in fact galvanized by the announcement, and the Republican Party suffered stinging defeats in the midterm elections. Against this backdrop, Gardner's morbid photographs met the public. And they arrived 2 days after the battle for the Antietam in October 1962, and the exhibit with Matthew Brady was a sponsor and fellow, was titled "The First Time in History the General Public was Able to See the True Carnage of War Before Being Buried." So not only was this probably the most violent day in American history, it also was the first time it was captured on photograph before they were all buried. So it was sort of, the people were not aware of what carnage existed. Holmes Sr. traveled to search for his son and future Supreme Court Justice, who was a captain of the 20th Massachusetts Regiment, and who had been shot through the neck and left for dead behind the enemy lines for part of the battle. So he sort of had his own skin in the game, one might say, by searching for his son. The martyrdom requisite to any potential redemption for the nation's crimes was thus no abstraction for Holmes Sr. He certainly the desire to both convict the nation for its crimes and to identify the redemptive meaning in such a scene of death would have been palpable for him, according to the author, and also insisted that the new medium for photography exposed a fanciful and the grand battle scenes painted exposed as fanciful the grand battle scenes painted by prominent 19th century French rivals Baron Gros and Horace Vernet, who made historic depictions of Napoleon at war and the French military gallantry in the Bourbon Restoration, and the colonization of Algeria and the Second Empire under Napoleon III, respectively. And the works of Holmes Sr. charge was produced to please an imperial master. So before this, a lot of these paintings were built to sort of glorify the imperial master. However, now that it was caught on film rather than in paint, it seemed much more gruesome. Rather than romanticize the military conflict, images of war and battles should have truth for the delineator, according to Holmes. and should have some conception of what a repulsive, brutal, sickening, hideous thing it is, this dashing together of two frantic mobs to which we give the name of armies, shouting and laughing hysterically accordingly. Valor retroactively is assigned to the confused and terrified protagonists. What do we owe, if anything, unburied Confederate soldier? It impressed upon Holmes Sr. and Holmes Jr., however, differed in his suggestions and fashioned a different experience, in that war did more than make him lose his virulent beliefs, it made him lose his beliefs in beliefs. So even perhaps Holmes Sr. was actually not in the battle, so maybe his interpretation was not even fully correct, whereas his son, Holmes Jr., even lost his belief in beliefs, but nonetheless still became a Supreme Court justice, so at least kept his head about his wits, I suppose. So moving to section 2, and these sections are not titled, so just bear with me, but we're moving along here. Every revolutionary liberal democratic founding has its secret drawers, according to the author, where one can find the illiberal ideas and mnemonic traces of illiberal acts in and through which the state came into being and sustains itself. The chapter begun with this disjunctive African-American grammar on the hollowness of liberty and the carnage of Antietam, and distant as they are from the American founding, as they disrupt the conventional legal and historiographic approaches towards 1776 and 1789. So these two quotes were brought up to give sort of counter history to the founding of the United States. The conventional approaches either ignore the American Civil War altogether or attempt to render it continuous with the Constitution of 1789, by arguing that apart from the abolition of slavery, the Union survived the war intact. The author argued elsewhere, although many contemporaries, including Lincoln, clung desperately to the idea that the Union as it was had been saved. And although this is true in a strictly geographic sense, as a constitutional matter, it is a position that demands indifference bordering on outright denial regarding the paradoxical terms of which emancipation, abolition, and suppression of the Northern dissent and the ratification of the Reconstruction Amendments occurred. Even revisionist scholars who see the American Civil War and Reconstruction Amendments as kind of refounding to seek to align to the trajectory of the period's conclusions and the natural rights identified in the Declaration of Independence. So a common theme we've seen throughout many of these chapters in the Oxford Handbook is a lot of people seek to see continuity, especially perhaps constitutional scholars want to see that perhaps nothing really changed after the Civil War, is sort of just a natural thing caused by the Constitution. However, according to Norman W. Spaulding, or perhaps some of these examples, maybe it wasn't as continuous as some endeavor to show. It is a difficult task, according to the author. As unchristian as the thought may be, redemption delayed at some point is redemption denied. For most Americans, particularly whites, the thought is unbearable. It is important to note that similar challenges attend English and French revolutions as well. So, the fact that there was a delay in the first place is some form of crime in itself, so there must have been something wrong going on. Otherwise, the abolition of slavery would have happened instantaneously. In England, for example, Steve Pincus contends it marked a fundamental break in the history of the British state. So this is the English Revolution, and the Whigs, such as Edmund Burke, insisted that unlike the French and other European revolutions, there had been no innovation, no revolution, but merely a sensible and backward-looking restoration of the older order. France, on the other hand, this is quote, that no Frenchman living in the second half of the 20th century can perceive the French Revolution from the outside. It is a dresser full of drawers, according to the author, in tricolor and no locks. The American Revolution, on the other hand, was also celebrated as transformative liberal democratic break with the past, a year zero. So if the American Revolution is thought of as a break from the past, why perhaps is the Civil War seen as a break from the past? And I think maybe the main takeaway here, and I don't think Norman Spaulding is 100% adamant on this, but I think that I think it cannot be denied that there is some sort of break. And a common theme throughout the chapter is something of evolution or a revolution. I think it can, in some ways, be both at the same time, and I think Norman W. Spaulding seems to allude to the same. Moving to section 3. Over the last few decades, according to the author, revisionist histories have drawn nearly every aspect of the conventional portrait into doubt. First, against the assumption of an epochal break leading to an unprecedented constitutional innovation, revisionist scholars have detailed extensive evidence of continuity with British common law and constitutional thought. So there's also this continuity back to Britain as well. Rhetoric and practice of the British Empire. Also, they've shown the extent to which American constitutional law is supported an imperial project not unlike Britain's, the absence of a contemporaneous consensus regarding the meaning of the Constitution as ratified, and the extent to which American constitutional law is in fact unwritten. The second against this assumption of restraint and constrained violence comes from Holger Hooke's Scars of Independence, America's Violent Birth, shows that when the independence movement escalated, although there was no guillotine in Boston, New York, or Charleston, as there were in Paris 2 decades later, it entailed forced exclusion not only of black slaves and Native Americans, but also of whites who did not subscribe to the revolutionary past. Those violent accidents were not unfortunate exceptions to the revolution, rather, especially where loyalists were concerned, were the norm. So there was much violence. And moreover, narratives of violence as much as ideology helped shape allegiances and mobilize supports. Stories of persecution, suffering, and sacrifice empowered American patriots and loyalists, and also Britons, to make sense of the revolution. Third, and relatedly against the assumption that lofty civic republican ideas motivated the American Revolution, scholars such as Robert G. Parkinson have shown the extent to which American elites have manipulated public opinion by demonizing the opposition and racializing patriotism. So, although perhaps some negative things could be said about some of the actions of the South, perhaps a lot of it was through northern almost propaganda. It included both black propaganda, hoaxes designed to agitate, and more pervasively the construction and dissemination of tendacious newsprint stories about slave rebellions instigated by British Indian massacres, supported by the British and on the Western Front, and Hessian accordingly notes atrocities to shore up an unstable political union. So there was all news sort of being passed around on both sides, sort of, that ultimately led to such carnage as in Antietam, based on some level on real events but heightened for effect. They grew more desperate as the conflict deepened, and patriots aimed to show the foreign shell to be cast off by the loyalists. Or to cast off the loyalists, pardon me. Parkinson notes their very survival depended on convincing people they were right. So if they lost their sort of public opinion, they would lose their war as well. To accomplish, or perhaps even their lives. To accomplish this vital, difficult task, they embraced the most powerful weapons in colonial cultural arsenal: stereotypes, prejudices, expectations, and fears about violent Indians and Africans. A true patriot was not just anti-British, but anti-slave, anti-savage, and anti-mercenary as well. This provided ammunition for attacking Indians and expanding the West long after the war had ended. During the Revolution, it was primarily the British who emancipated the slaves. Liberty was a right claimed by escaping behind British lines often. In the Constitution, 6 clauses directly concerned with slaves and their owners. 5 others have implications for slavery that considered and debated by delegates to the 1787 Constitutional Convention and citizens of states during ratification. All but one of these might be ended, or clauses protects the slaver. Only one points to the possible future by which the institution might be ended. So in Norman W. Spaulding's reading of the Constitution, specifically focused on slavery, only one perhaps alludes to the abolition of slavery. So for those who um, believe in absolute continuity, why did all these other clauses that reference slavery have no impact and perhaps even defend the slaver? The most difficult obstacle, according to the author, is how to count the population and thus structure representation in the national government, and how to structure taxation and other national powers over the economy profoundly influenced by slavery debates. And also political slavery rhetoric was used both for and against. So there's these other forces too that had implications on slavery, like should if there could be additional tax revenue if the slaves were emancipated, for example. Moving to section 4, according to the author, this is section 4 of 5, so, pardon me, of 6, so getting there. But with few notable exceptions, according to the author, powerful revisionist critiques have failed to penetrate into popular consciousness or judicial interpretation of the founding. Some 21st century Americans prepared for memory work to remove from public spaces certain Confederate monuments and accept the evidence of moral failures on the part of individual founders, and strip the names of slaveholders from certain university buildings, and usually under the banner of vindicating the ideals of the Declaration of Independence. In this way, dissociation of slavery from the founding is paradoxically recapitulated in the very revisionist memory work supposed to address and preserve the relationship between the two. So by cutting these links, it actually destroys the continuity in the first place. Part of the failure of revisionist critiques of the founding to penetrate popular consciousness and judicial interpretation is historiographic, according to the author, and collective memory and history interact in complex ways which historians have just begun to rigorously probe. The tendency is to replace one set of heroes with another. As importantly, over the last few decades, the discipline of history has moved gradually but decisively away from the study of political history towards the broader analysis of social life. And therefore we have this sort of comparison between social and political history, which is conveniently written in the Oxford Handbook of Legal History, described as sort of a political history would be a top-down approach, and social history would be a bottom-up approach. So I think that's a great way of eye-opening way to look at these two fields. Ways in which social, economic, and cultural perspectives, along with the elements of material culture, reflect, subvert, and ramify the formal setting of law and politics. These developments in the field of history have coincided with a sharp turn towards empirical studies in political science departments, and foxes have been, according to the author, the foxes have been replaced by abacus-wielding hedgehogs, as well as a retreat from the grand synthetic analysis on the part of prominent constitutional law scholars, academic audience with expertise to take up, reconcile, translate, and amplify implications of revisionist critiques from public consumption. It appears to have diminished even as a field of legal history blossoms, and ordinary briefings before the Supreme Court is increasingly and enthusiastically supplemented with historians' briefs attempting to correct and play into the court's originalist impulses. So maybe one of the key takeaways from this chapter is it is certainly important to read the Constitution, and I would say the Federalist Papers too, which I think is all kind of included in constitutional law, but one must also look deeper into the historical context. For example, when Alexander Hamilton, John Jay, and James Madison were writing the Federalist Papers, of course they focus on certain things, but by reading it, one might not get the full picture of what things were like at the time. And especially if one were only to look at paintings, one would really start to get a deceptive view. That's also always been an anti-establishment tradition in American public life, defined by skepticism of the professional expertise and authority. So, but maybe there's sort of also a gap between the constitutional scholars and historians. It's often associated with populism, but political and epistemological roots are revolutionary as well. The idea that people know best is also hard to remove, and the 21st century strain is particularly robust as well. At the same time, conservative legal scholars, judges, and political figures have drawn upon and supplemented the conventional account of the founding in an effort to shape public opinion and characterize revisionism as both irresponsible and unpatriotic. So but I think it's one cannot completely get rid of revisionism, even if it is unpatriotic and such, or irresponsible. But I don't think it is. I think that a certain amount of revisionism might be necessary. Yet even if these so-called foxes were not endangered in the Academy, their influence would be limited. Yet the cornerstone of constitutional law to see perfection in the founders of the Constitution is inevitable, and perhaps the contradictions in the Constitution are necessarily caused suffering and death like Antietam, and therefore perhaps it could be even seen as a covenant with death rather than a moral regeneration of the nation. Holmes Sr.'s reaction to the revolution is more common than Holmes Jr.'s loss of belief in belief, and perhaps reviving their strength on both sides. So if one does prescribe to the Constitution having been perfect, and there is some sort of absolute continuity, why was it this? So was it then just a covenant with death if it was fully responsible for the Civil War? Thus, the singular elasticity and resilience of the ideals of the American Revolution, their capacity to support diverging starting points for redemptive projects, we could add the infinite capacity for commemoration. So this obsession, according to Furet. So much the better, one might conclude, as long as the bloodshed on the battlefields like Antietam is not forgotten. That is, as long as the elasticity of revolutionary ideals and divergent trajectories of redemption supported them are channeled into ordinary forms of constitutional debate. So moving to section 5. Anyone, according to the authors, sensitive to the pathologies of repetition, compulsion, must wonder if there is not something missing in this approach to the founding, if there is not a toll associated with the failing to escape what Furet called the tyranny of the historical actor's own conception of their experience and the myth of origins. In the French context, according to the author, Furet explains the tyranny contrast the famous history of the French Revolution written by Jules Michelet with Alexis de Tocqueville's less celebrated critique. So from my standpoint, although accordingly Alexis de Tocqueville's critique on the old regime and the French Revolution is less popular, but of the two, that is actually the one that I have read, so go figure. So notwithstanding the deeply held egalitarian ambitions of the revolutionaries, de Tocqueville argued most significant practical effect of their actions was to complete the centralization of the state power begun by the monarchy during the ancien regime, the old regime, and focusing on the writings of revolutionaries in the manner of Michelet, he sought to reveal and validate their aspirations through the primary source materials and attempted thereby to canonize one or another triumphalist narrative, national narrative, and obscure the extent to which the supposed ruptures and innovations of the revolution merely accelerated a prior political and social trend initiated by Richelieu and Louis XIV. So de Tocqueville actually does sort of show this continuity between the revolution and the events leading up to it. Historians accordingly need to make a choice between Michelet and de Tocqueville, and it's not a choice between Republican and conservative interpretations, respectively, for both are still linked to the common definition of the problem, which is precisely what Tocqueville rejected, according to the author. What separates the two is that Michelet brings the revolution back to life from the inside, that he communes and commemorates, while Tocqueville constantly examines the discrepancy he discerns between the intentions of the actors and the historical role they played. So on that note, they both sort of advocate for some continuity, but de Tocqueville sort of notes that they were in some ways blind of this continuity. De Tocqueville not only questioned that transparency or coincidence, he thought it actually masked the fundamental disconnect between the human action and its real meaning. He believed that there was a gulf between the revolution's true outcome and the revolutionaries' intentions. Furet insists that Tocqueville's methodological turn is the most important in its entire historiography of the French Revolution, the very reason the book is ignored, supposedly. Little appetite in France for lingering on the respects in which the French Revolution betrayed its own ideals and consummated a long-standing monarchic aspirations to centralize administrative power on the levers of state power. So supposedly it's the less popular history because it reveals sort of an unfortunate truth of the revolution, that it was sort of just the result of an obsessive centralization. And then we saw Napoleon the First later comes and sort of fills in that void. But nonetheless, the Democracy in America is very widely read, at least in the American context. So Alexis de Tocqueville's probably two most famous novels are Democracy in America and On the Old Regime and the French Revolution. Two very, very fascinating books I recommend anyone read on the two nations. So very, very, very fascinating. In the American context, revisionists have made a methodological turn to expose the continuities as well as the failure of the egalitarian aspirations. There's a tendency still to focus on the protagonist's archive, which is a polysemic, which is meaning polysemic, which means many possible meanings. I didn't know that word, polysemic. The assignment of moral authority and agency different for revisionists, but share the conventional accounts, the same definition of the problem, the same logic of commemoration once again. So there's also, I think, to commemoration we can also add sort of a willful blindness. Finally, although the discrete inconsistencies and contradictions are more commonly raised, they are almost invariably swept up in redemptive dialectics. Missing, according to the author, even from the revisionist accounts, is not only the fully articulated theory of the respects in which the law is constituted in and through popular resistance, but also an understanding of how excess, violent excess, and above all the terror of violent excess influences both the ordinary operation of the law and the state's legal and political responses to exigent circumstances. Charles Tilly has written, "Revolutionary situations consist in convergence of variable political conditions that appear widely outside revolutions." The same can be said of revolutionary resistance. Simply cannot understand the American Revolution or the legal order established by the American constitutions of either 1789 or 1865 as long as revolutionary resistance and its various legacies, remainders, and analogues are treated as aberrant, antinomian exceptions. That's why I think Norman Spaulding doesn't believe in absolute continuity and absolute non-discontinuity. There are outliers, but there are also places we can fill in the gaps, and maybe these outliers like Antietam aren't quite as big outliers as we thought. Moving to section 6. The author notes, quote, I confess that there are several parts of this Constitution which this is a quote from Benjamin Franklin, who's one of my favorite authors, or one of my favorite thinkers, I would say. I confess that there are several parts of this Constitution which I do not at present approve, but I am not sure I shall never approve them. For having lived long, I have experienced many instances of being obliged by better information, on fuller consideration, to change opinions, even on important subjects which I once thought right, but found to be otherwise. Steele, a Protestant, in a dedication to the Pope, notes that the only difference between our churches in their opinions of the certainty of their doctrines is the Church of Rome is infallible and the Church of England is never wrong. So sort of also a little bit facetious as well, but nonetheless that Benjamin Franklin was open to changing his opinion. And I got into some debates on this, but I actually think a good politician does change their mind, whereas a lot of people I've spoken to think that a good politician should never change their mind, but then I think they become sort of commoditized. And these are words from the speech from Benjamin Franklin read on the last day of the Constitutional Convention, 75 years to the day before the Battle of Antietam. Historians and other commentators have focused more on an offhand remark by Franklin at the close of the convention comparing the result of that summer's deliberation to a half-eclipsed sun painted by George Washington on George Washington's chair. Franklin mused that at different points in the deliberation of the convention during the summer he had looked at an emblem with trepidation, but now at length I have the happiness to know that it is a rising and not a setting sun. The speech, however, is about the fallibility, not redemption. about not knowing, or rather knowing, that one is prone to error and that one must act in the face of the debilitating knowledge, and sounds considerably more like Holmes Jr. than Holmes Sr., according to the author. It's also a deeply political speech, according to the author, as Franklin was the head of the Pennsylvania Abolition Society in 1787 and had long promised to act in concert with anti-slavery activists. In that capacity, he had agreed to present a petition opposing the slave trade at the Constitutional Convention, a pledge he failed to keep. It was not a change of the opinion over time and after deep reflection, but a subordination of one firm-held belief, or at least professed conviction, over another. It also needed all the drafters to sign. He said, "I cannot help expressing a wish that every member of the convention who may still have an objection to it would, with me, on this occasion, doubt a little of his own infallibility, and to make manifest our unanimity, put his name to this instrument." So he himself he was anti-slavery, but at this time he sort of broke his promise just so the Constitution could be signed. But maybe that had large ripple effects, and maybe if he had said something there, and then perhaps there might have been no Civil War. In fact, it was drafted by the states present, so it wasn't even a unanimity. Not all the states, because Rhode Island had appointed no delegation, and not all the delegates had come. For one reason or another, almost a quarter of the members had left the convention, and only 4 states still possessed their full delegations, so it really wasn't unanimous even after this. And this appearance of unanimity existed only. More than a few of those who remained were opposed and needed convincing, so even of this subset that still existed, some were still not unanimous. Franklin's motion, however, passed, and all but 3 delegates affixed their signatures. So still almost everyone but 3. Readily apparent from the notes of the debate that the delegates remained in profound disagreement about what signing either did or did not signify. No pun intended to signify. Some saw as not just an endorsement of the Constitution, but a solemn pledge to support ratification. Others, while supporting the motion, emphasized the refusal to sign would be read publicly as opposition to the instrument. So what does even the signing or not signing mean? Eric Slaughter is right to observe, according to the author, how easily it is for the modern readers to forget the lack of unanimity during the founding period, to ignore the strategies of compromise the framers, like Franklin, employed to produce a veneer of consensus, and to overlook the lengths to which historians have sometimes gone to cover over dissent. It's an unsettled ambiguity rests in the very signatures of the framers to the instrument of their making. Franklin's invocation of fallibilism may have been strategic and less hard-won than Holmes Jr.'s. Given his decision to pocket the anti-slavery petition he was charged with presenting, it can hardly be seen as heroic, according to the author. For that reason, because of the disjunction between its purpose, its language, and the contemporaneous actions and omissions of its author, it warrants closer analysis in his stories of the founding. So once again, going back, one can and must read the U.S. Constitution. It's not long if one is interested in American constitutional law, but it would be important to look at the history that surrounded it too. Indeed, it's emblematic of the founding, but the charge of the historian, and perhaps too the constitutional lawyer, according to the author, is not to redeem the founding, nor is it merely to reveal unsettled ambiguities. The charge is to see ambiguities, contradiction, and error as constitutive, to constantly test the paradox of unanimity made manifest in doubt, entails reading the Constitution, the written text itself, once again it's not too long, as an expression of fallibilism, not the canonization of one set of beliefs over another. What Holmes Jr. famously called fighting faiths, and certainly not as an ideological fulfillment or flat betrayal of revolutionary ideals. A history that meets this charge is no more supplement to the text and structure of the Constitution. It is their measure, a condition of their legibility. So that is a very, very fascinating chapter by Norman W. Spaulding to discuss that content, which is on the slide if one can see it. This chapter is in Section 5, Illustrations, Doing Things with Legal History. It is Chapter 53 of the Oxford Handbook of Legal History, titled Redeeming the American Founding. So Norman W. Spaulding's position is the Nelson Bowman Schweitzer and Marie B. Schweitzer Professor of Law at the institution Stanford Law School. Suggested readings include Federal Courts in Context with Davis S., Cherminsky E., and O. Smith F., published by Aspen Publishing in 2023. Next suggested reading is a chapter, Online Dispute Resolution and the End of Adversarial Justice in Legal Tech and the Future of Civil Justice, published by the Cambridge University Press in 2022. And a third book, Civil Procedure, or a second book, but a third suggested reading, titled Civil Procedure, Cases and Problems, 7th edition, with Babcock B., Mazzaro T., and Giles M., published by Walter Kluwer in 2021. Areas of expertise include civil procedure and litigation, complex litigation, ethics and professional responsibility, federal courts and federal jurisdiction, and legal history. Moving to the quotes that I've collected on the slide here. Every revolutionary liberal democratic founding has its secret drawers where no one can find the illiberal ideas and mnemonic traces of illiberal acts in and through which the state came into being and sustains itself. Second and next quote. Antietam was the single costliest day of combat in American history, leaving 25,000 Americans dead or wounded. The battle was significant, not so much for its immediate tactical outcomes as for the massive bloodshed. More than twice as many Americans were killed in a single day than in every other 19th century American war combined, and the revolutionary transformation in terms of the war that ensued. Third and last quote. The charge of the historian, and perhaps too the constitutional lawyer, is not to redeem the founding, nor is it merely to reveal unsettled ambiguities. The charge is to see ambiguity, contradiction, and error as constitutive, to constantly test the paradox of unanimity made manifest in doubt. And in terms of the two images, we have in the top right Williams College, where he received his Bachelor of Arts, and in the top left we have Stanford Law School, where he received his Juris Doctor and also teaches as a professor of law. Moving to the chapter and biography of Peter Lindseth. So this chapter is in Section 5, Illustrations, Doing Things with Legal History as well, and it is Chapter 54 of the Oxford Handbook of Legal History, titled Foundings, European Integration, by Peter Lindseth. So as for the biography of Peter Lindseth, he is the Olympiad S. Yoffe Professor of International and Comparative Law at the University of Connecticut School of Law. He is also the Director of Graduate, International, and Non-JD programs, coordinating oversight of LLM and SJD programs, along with Martin Flynn Global Law Professor Program and the Law School's array of exchange and visiting scholar relationships. He's the recipient of the 2012 Berlin Prize and the Fellow of the American Academy in Berlin. His expertise includes comparative public law, including both administrative and constitutional law, corporate and regulatory compliance, European integration, and legal history. He received his Bachelor of Arts and Juris Doctor from Cornell University and his PhD from Columbia University. He was a visiting professor. He's been a visiting professor at Princeton, Yale, Tilburg in the Netherlands, Queen Mary University in London, Paris 2, which is 2, Pantheon Assas, and I Marseille in Marseille. And he has also held the Fellowship Research Associateships at the European University Institute, the French Conseil d'État, and Max Planck Institute for European Legal History, as well as the NYU School of Law and the Oxford Center for International Studies. He came to the University of Connecticut from Columbia Law School, where he was the Associate Director of European Legal Studies Center, and as well as a teaching fellow or associate in law and managing editor of the Columbia Journal of European Law. His publications include the Oxford Handbook of Comparative Administrative Law, where he was a co-editor with Kane P., Hoffman H., and Ip E., published by the Oxford University Press in 2020. Comparative Administrative Law, a second edition, where he was co-editor with Rose Ackerman S., Emerson and Emerson B., published by Edward Elgar Publishing in 2017, and Digital Democracy in a Globalized World, where he was co-editor with Prinz C. Kujipers C.M. and Rosina M., published by Edward Elgar Publishing in 2017. He has over 7 books, according to my counting, and over 25 book chapters, so many publications. So moving to section 1. Also, these sections are not titled, so bear with me, but hopefully we will follow along smoothly. So he starts off with referencing the catastrophe of 1933 to 1945, indeed of 1914 to 1945, is rightly seen as a central impetus behind the founding of European integration in the 1950s. A crucial dimension of the founding, however, also relates to the advent of the modern administrative 20th century Europe, state in 20th century Europe, what we may call the post-war constitutional settlement of the administrative governments after 1945. So sort of the founding of the European state after the Second World War. Beyond the functional demands of the post-war reconstruction, along with the desire to transcend excesses of nationalism, the post-war period almost was a moment in Western European history when the constitutional foundations of modern administrative government were also secured. In the decades following the end of World War II, major Western European countries had arguably found the formula for a new form of government, designed to meet a larger pattern of obligations in the emergent welfare state, something they had been actively seeking since the end of the First World War. New form of governance was built on a transformed understanding of the legitimacy of regulatory power delegated to the executive and administrative spheres, combined with checks exercised by parliaments and judicial institutions. A reconciliation of democracy and bureaucracy was also took place. It's no coincidence, given the fundamentally executive and technocratic character of European integration. There are several prime movers in the process of European integration in the 1950s, and some of these individuals include Jean Monnet, Robert Schuman, and Konrad Adenauer. Had also been major players in the construction of their respective national post-war administrative states as well. And sort of, we get to this, there's this book on heroes, hero worship, and the heroic in history by Carlyle, which was refuted by Tolstoy in War and Peace, but nonetheless there's this question is, was this change in Europe the result of many great people, or was it the result of all the people? So were there heroes in this shift? After the disaster of the 2 world wars, all major countries, according to the author, in Western Europe sought to reconcile the increased functional demand for delegated regulatory power with their historical experiences and constitutional traditions. Although legal and institutional approaches to the problem would differ in particulars, each country's solution followed the same basic pattern, which is that the vast majority of rules of general application would no longer be in the form of traditional legislation passed by Parliament, but would now take form of regulations or other subordinate legislation produced within executive and administrative spheres, adopted pursuant to enabling legislation or framework laws. This democratic legitimation of these rules would no longer be directly through the enabling legislation to combine subsequent hierarchical oversight of the administrative sphere of government ministers, who were in turn responsible before parliaments. So sort of this higher level of government, almost one could think of it as analogous to a federal European government. Supplementing these forms of oversight were legal controls enforced by courts and other court-like administrative tribunals, which served as a commitment mechanisms. The language of principal legent theory. to ensure administrative governance remained within the confines of both statutory and constitutional bound. So this sort of envisioned federal European government that is also sort of responsible to be before courts and other court-like administrative tribunals. So, of course, the European Union is not entirely a political entity, it is also a legal entity, and also has legal responsibilities and legal checks and balances. As almost the same historical moment, these national forms of administrative governance were consolidated in Western Europe. The administrative governance also began to take on an additional supranational dimension, which involved a shift of regulatory power, both in terms of rulemaking and enforcement and adjudication, to institutions operating outside the confines of the nation-state. Beginning with the establishment of the European Coal and Steel Community, or the ECSC, in 1951, and continuing with the founding of the European Economic Community, the EEC, and the European Atomic Energy Community, Euratom, in 1957, European integration is built directly on several key elements of the administrative governance as it was emerging on the national and supranational levels in the aftermath of World War II. So my takeaway here is that it was largely these, in some ways, led by economic initiatives that can cause for greater integration within Europe. As a political matter, integration was built most importantly on the constitutional predominance of the national executive, not merely as a legislator in his own right, but also as a first line of democratic legitimation over policy making in the administrative sphere, whether national or supranational. Integration was further dependent on political and institutional ascendance within the administrative sphere of the technocrat, whose primary bases for legitimacy were a combination of seemingly depoliticized expertise, ministerial oversight, as well as judicially enforced respect for tenets of administrative legality. There's also the European integration was built on enabling legislation in a new guise, in that the various community treaties and related agreements, which, like enabling legislation and framework laws on the national level, did not specify most regulatory norms directly, but rather delegated this normative power to executive and technocratic institutions, albeit, according to the author, ones which now extended beyond the strict confines of the nation-state. Finally, according to the author, the process of European integration entailed an important judicial commitment mechanism, the European Court of Justice, the ECJ, not merely to review the legalist of community norms, but also more unexpectedly to scrutinize the conformity of member state laws with the goals of market integration as set forth in the treaties. So, therefore, in seeking to understand the founding of integration, it is equally crucial to remember the new supranational apparatus not only depended upon, but also disrupted the forms of administrative governance that were emerging on the national level in the post-war decades. Sort of a clash between the national and the supranational forces. And their dependence could be seen primarily in the crucial role played by the national executives in providing shared control and oversight of supranational technocrats. At the exception of the European integration in the early 1950s, what distinguished the supranational administrative governance from the national counterparts was the ambiguous legal role of national executives in the legitimation of technocratic norms produced at the community level. So one of these differences is that these at the community level they actually have greater responsibility because they're responsible to, for example, the European Court of Justice, whereas at the national level they're only really responsible within their own jurisdictions. Although it committed European federalists like Jean Monnet saw the essence of supranationalism as supranationalism, as technocratic autonomy from even national executive control. Much of institutional politics of European integration in its first 3 decades would center around the largely successful effort of national executives to assert their hierarchical legal authority, severally and collectively, over community rule making. Legitimacy of regulatory norm production at the community level was primarily mediated through cabinet ministers and especially through the plebiscitary leadership of chief executives as in an administrative state. So these are sort of, I guess, maybe general observations because certain nations might differ from other nations, but nonetheless, this applies generally to the nation relative to the supranation. By contrast, nationally mediated legitimacy was much more difficult to maintain in the supranational judicial context, which gave rise to significant disruption in post-war constitutional settlement in the process of European integration. On the national level, courts and court-like jurisdictions, administratives, such as the French Conseil d'État, saw one of their main functions to be constraining the normative autonomy of the administrative sphere in key areas. These constraints took form of principles of natural justice designed to protect individual rights or more importantly, the application of constitutional limits on delegation designed to protect certain core democratic functions of the national legislature. The very purpose of courts and court-like jurisdictions, administratives, in post-war constitutional settlement was thus to serve as an independent check on the exercise of executive and administrative power in the interest of the legislatively and constitutionally defined policy goals. So although the French Conseil d'État is a key body in regulating the national government in France, what power does the French Conseil d'État have in the community level government? When the independent check was transferred to the supranational level, certain contradictions arose. On one hand, consistent with the post-war constitutional settlement, the ECJ, the European Court of Justice, sought to advance rules of law in supranational level through the enforcement of procedural protections on behalf of private practice in face of community action. Although the court proved to be parsimonious in granting broad standing to private parties, almost certain kinds of regulatory conduct at the community level. On the other hand, in the break with the post-war constitutional settlement, the court consistently geared its case law towards promoting the normative autonomy of community institutions, including, most importantly, the court's own autonomy. So there's this necessity that these judicial bodies need to be autonomous, but then there's also this clash in that they do need to be responsible to the bodies at the national level. So how can it be autonomous and not autonomous simultaneously is a question that is, I'd say, still being figured out. From any kind of specifically national control that might impair the achievement of the community interest as the court defined. Thus, while national executives were working hard in the 1950s to reinforce member state control over regulatory decision-making in the community, in a matter consistent arguably with the executive element of post-war constitutional settlement, the ECJ was laying the groundwork for a very different understanding of the nature of the European integration. According to the author, implicit in the court's jurisprudence in early decades of integration was a conception of community as an autonomous level of governance in a federal-type system, with constitutional legitimacy of its own independent of member states rather than merely a mediated administrative legitimacy as the member state's regulatory agent. The ECJ thus became the driving force behind the effort to transform the community, conceptually from the legal arrangement among individual sovereign states governed by a solution that was neither a European parliament nor government nor people on which to build an integrated polity or market. The only way to build Europe without Europeans was to address ourselves to independent personalities whose decisions would be binding on the national governments. Therefore, there was this quasi-judicial powers with the American term authority was applied, and Monet accepted his proposal immediately. And therefore, it was the international law was governed in vertically integrated new legal order, and it was therefore a kind of autonomously constitutional order, as the court so boldly announced in 1963 in the celebrated judgment in Van Genderen en Loos, which we will talk about more in a bit. This constitutional approach was no doubt deeply influenced how lawyers and legal scholars have come to understand the process of European integration over the last half-century. Nonetheless, a flaw in the court's approach has always been that it assumes that what is fundamentally in historical doubt, that the supranational apparatus has in fact attained its own democratic constitutional legitimacy. To be sure, according to the author, European integration possesses various kinds of legitimacy, both legal, technocratic, and functional, and these have been crucial to supporting the now vast regulatory power of the EU. Nonetheless, the EU governance today still depends on member states to supply the most robust forms of democratic and constitutional legitimacy, precisely as one would expect of a system in which the principles, in an ultimate legitimacy sense, remain national, while regulatory agents are increasingly supranational. So, the principles, according to the author, are national, but the agents are supranational, increasingly so. This disconnect between the extent of the EU's regulatory power and its sources for robust democratic constitutional legitimacy on the national level, and therefore lacking such legitimacy in its own right, has deeply shaped the evolution of European public law since its inception. So this is a lot of information, at least as particularly like for anyone who's not familiar with this EU integration, but nonetheless we'll detail this as we go forward, particularly as we move to section 2 now. So that was an introduction. I apologize if that was a lot of information, but hopefully it will all make sense soon. For Western European elites faced with the daunting task of reconstruction in the aftermath of World War II, the New Deal in the U.S. seemed to offer a successful model of institutional and regulatory innovation in the face of a devastating crisis. The situation at the end of the war will resemble that in America in 1933, though on a wider and deeper scale, wrote David Mitrany, who was a Romanian-born naturalized British scholar of international relations in 1943. So we must note at this time the England, or the Britain, or the United Kingdom, was going towards integration with Europe. So this is before Brexit, long before Brexit. And for the same reasons, the path pursued by Mr. Roosevelt in 1933 offers the best, perhaps the only chance for getting a new international life going. So supposedly, the European integration was based in some part off the actions of Mr. Roosevelt and the New Deal. In A Working Peace System, appropriately subtitled An Argument for Functional Development of International Organizations, a book alluded to developing the ideal of that public institutions should evolve as a function of the problems they were established to solve, rather than being governed by traditional normative constitutional commitments. So build these institutions based on the problem they're hoping to endeavor to solve. On the national level, there will be a separation of powers. On the international level, national sovereignty. Mitrany argued the emergence of specific administrative state of the New Deal type was the peculiar trait and indeed the foundation of modern government, whose purpose and power was being determined less by constitutional norms than by practical requirements. Mitrany hoped to harness this functionalist dynamic in service of a peaceful change among states, allowing New Deal type administrative governance to do internationally what it had done nationally. And key would be to the creation of a detached international civil service with a new conscience of independence and practical solving on the transnational level. So people familiar with the New Deal might realize that it was in some ways a costly initiative, and therefore some of the criticism of the EU is that it certainly is more costly than having than its non-existence, but if it is built for specific purposes, as was the New Deal designed, and while the checks and balances where there's on the national level separation of powers and on the international level national sovereignty, it should in theory bring value. The same mindset guided the leading advocates of the European integration in the 1950s. Most important of these were John Monnet, previously mentioned, who on behalf of the French government led the drafting of the integration's founding document, the Schuman Declaration of May 1950. The only institution mentioned in the declaration was an independent technocratic body, titled The High Authority, a name intentionally evocative of the administrative agencies of the New Deal model, for example, the Tennessee Value Authority. Paul Reuter, a law professor, member of Monet's drafting team, later acknowledged that the proposal for a high authority stood in disquieting solitude. Its independence was in some sense a desperate solution because there was neither a European Parliament nor government nor people on which to build an integrated polity or market. The only way, accordingly, to build Europe without Europeans was to address ourselves to independent personalities whose decisions would be binding on national governments. Therefore, these quasi-judicial powers with the American term authority, and Monet accepted his proposal immediately. Thus, the original French proposals of a high authority was to serve as a kind of autonomous regulatory agency on an extraordinary novel type, possessed with normative power delegated from national parliaments, but otherwise free from having its decisions legitimated by subsequent national oversight, notably via the national executive. The formula proved unachievable, however, at least in a political sense, as over the course of the negotiations of the Treaty of Paris in 1951, which established the ECSC, other countries pressed for the establishment of a Council of Ministers drawn from the national executives to oversee the high authority activities politically, and therefore a new Court of Justice to oversee the activities legally as well as a common assembly. So the powers of the high authority were severely limited as things progressed, and therefore the future of European Parliament, whose members would be drawn from the national parliaments in order to provide some modicum of parliamentary representation at the supranational level. So sort of more responsibility to the national jurisdictions. The ECSC negotiations suggested a fundamental impossibility of separating the purportedly technical from the political, a central distinction of the functionalist framework for supranationalism, and therefore was a weakness of functionalism. Perhaps it was one reason it was eventually displaced by the so-called neo-functionalist theory, which was a newer framework that had the virtue of recognizing that the initial decision to delegate to supranational bodies was the byproduct of a highly political rather than merely functional/technical process. Like functionalists before them, neo-functionalists of the 1950s, most importantly Ernst Haas, still foresaw the driving force behind any subsequent expansion of supranational regulation competences would be the neutral imperatives of functional problem solving and the infamous spillover effect. It was theorized by lower level technocrats operating in relative autonomy from political control by the national executives and in an alliance with a subnational economic interest committed to expanding integration. Walter Hallstein, a German negotiator in an integration process in the 1950s and later president of the European Commission in the 1960s, grounded his fact in Europe's federal destiny in purportedly ever-expanding psychologic or substantive logic, entailing precisely the neo-functionalist spillover of integration from one independent domain to the next. So we I think makes sense in that, for example, a diplomat or a sort of a leading government official at the national level should maybe naturally progress to the European level, but maybe it's not necessarily representative, so then therefore there should be some sort of mandated proportional representation as well within this supposedly high assembly. Yet even with neo-functionalism's refinement to account for the role of politics, at least initially according to the author, the theory still did not prove to be a robust explanation of the integration phenomenon as subsequent workings of the ECSC demonstrated. The basic premise of establishment of the Council of Ministers was that technical decision-making at the community level would inevitably impede on political questions of values or allocation of scarce resources, for which more legitimate political oversight would be necessary. Thus, according to the author, in negotiations of the Treaty of Paris, organizational questions were intimately bound up with intergovernmental effort to determine as far as possible the extent and direction of national gain and loss before the high authority began to function. Given the legal framework within the high authority was supposed to operate, it is hardly surprising, according to the author, that the supranational technocracy did not subsequently act as a neutral functional regulator as the neo-functionalists claimed. The organs of the ECSC arguably came into existence in the legal form they did, including most importantly with the key role played by the Council of Ministers, drawing from their national executives precisely because the issues involved could not be reduced to the merely functional level. Although the functionalist and neo-functionalist advocates of integration underestimated genuinely the political character of the ECSC's regulatory activities, their emphasis on the technical character of the community corresponded in reality in at least one important sense. Precisely because the coal and steel sector was broadly perceived to involve the regulatory issues of the largely technical or functional nature, the supranational delegation was politically problematic, requiring little or no parliamentary involvement, whether nationally or supranationally. So then there's even the question, should it be in the private sector? Should it even be government in the first place? The same sort of stratagem was available once the process of European integration shifted to national defense and control of armed forces. In the French proposal in the fall of 1950 for the European Defense Community, EDC, culminating in the signing of the proposed EDC Treaty in the May of 1952, quickly revealed the limits of the political support for supranational delegation. Ironically, it would be the French National Assembly that would ultimately kill the EDC in 1954, but concerns over unbridled supranational power that the EDC raised would shadow integration in the remainder of the decade. The Treaties of Rome of 1957, most importantly establishing the European Economic Community, would retain quadripartite organization form of the ECSC, or a National Executive Council of Ministers, or a supranational technocratic body called the European Commission, or a parliamentary assembly, and a court of justice. But there would be one major substantive difference between the institutional structures of the new EEC and the ECSC, that the legal balance of power under the EEC would shift formally and decisively towards the Council of Ministers, which gained the final say in most aspects of legislative normative community at the community level. So many different organizations coming up here, but largely some of them are led by economic influences, some are led by needs for protection. One of the leading protagonists in a lot of European integration is France, but in some cases they sort of took a step back as well, so it's nuanced, not exactly linear, but this is a very, very detailed history, and it would take I don't think one individual could ever fully fathom this European integration, but I think Peter Lindseth has done the best effort I've seen thus far, and there's many of these things I had no idea about. So continuing on, this did not mean, according to the author, the effort to define the treaty balance between the Council and other institutions would be easy. The task was given over to the group of nationally designated legal experts called the Groupe Juridique, which was responsible for drafting institutional and legal provisions in treaties of Rome. Given the ultimate decisional power in Council, the Groupe Juridique inserted provision designated to protect the Commission's unfettered discretion in making legislative proposals, therefore the cornerstone of what is called the community method. Although they largely ignored at the time, the decisions eventually proved controversial, particularly in France after de Gaulle returned to power in 1958. The same was also true of the planned shift to qualified majority voting in Council over the course of the transition period, which was to last 12 years from the entry into force of the treaty and divided into 3 parts. De Gaulle later asserted to accept the majority voting after we had decided to take our destiny into our own hands. At home would leave France exposed to the possibility of being overruled in any economic matter whatsoever, and therefore in social and sometimes political matters as well. So de Gaulle was certainly not in favor of this, accepting the majority voting, because he thought that France could be at the blunt end of the stick, which was certainly possible. De Gaulle, however, held off his battle over the qualified majority voting until the final year of the second stage in 1965, by which time he had secured his principal policy goal from integration. It was a generous community-based support for French agriculture under the terms of Common Agricultural Policy, the CAP. And de Gaulle long recognized, however, that the move to qualified majority voting in the third stage would greatly strengthen the position of the Commission. This embryonic technocracy, he calls it, for the most part foreign, which would no longer need to be satisfy each and every member state in order to see its legislative proposals adopted in Council. So despite de Gaulle's reservation, he saw that this majority voting was necessary to get the Commission off its feet. Or on its feet, pardon me. The episode that followed is that the empty chair crisis of 1965, culminating in the Luxembourg Compromise of January of 1966, was often construed in subsequent decades as introducing a right of national veto in the community's early legislative procedure, in which the member state could demand a council decision by unanimity when it believed that a very important national interest was at stake. This understanding is something of a historical misconception, according to the author, in that the Luxembourg Compromise arguably only codified the traditional practice of consensus politics in the council. So perhaps it was it already existed, but the Luxembourg Compromise just sort of validated, thus making the reassertion of an older set of ground rules for European integration, and that community norm production needed to be mediated in some way through the national executives, just as in the administrative state. The culmination of this institutional reinforcement of national executive oversight at the supranational level would occur just under 10 years later, in 1974, in the development with the significant long-term effects of the political life in European integration. At the initiative of French President Valéry Giscard d'Estaing and German Chancellor Helmut Schmid, the heads of state and government of the member states formed themselves into the European Council, a body initially outside the confines of treaty law, to serve as a forum for the chief executives of the member states to decide on future direction of integration policy. Assembling in them semi-annual summit meetings, the purpose of the European Council was to provide political guidance to Europe's supranational regulatory process. Seemingly blatant intergovernmentalism, the European Council appeared to federalists and other pro-Europeans as a fundamental reversal of the progress towards integration. The view assumed that most important measure of such progress was the degree of supranational normative autonomy in the community decision-making, according to the author. More persuasive historical interpretation is, rather than reversing the process of European integration, the establishment of the Council actually signified a wish to extend community decision-making to new areas in response to changes in national policy objectives arising from fundamental change in economic circumstances of Western European countries after 1974. Therefore, the establishment of the European Council suggested that the process of European integration, to have any hopes of continued development with the end of the 3 decades of steady post-war expansion, the Trente Glorieuses, 30 years of glory, clear political backing by the national chief executives would be needed. Therefore, technocratic policy development in the Commission, the community mode, even under ministerial supervision, Council of Ministers, would not be enough. Some form of leadership by heads of state and government was therefore required. Moving to section 3, there's 4 sections total, so almost there. While the reinforcement of the national executive oversight undoubtedly made it difficult for the Commission to play the neo-functionalist envisioned for it, a kind of supranational vanguard of the integration process, there was another supranational institution that enjoyed considerably more freedom to pursue the same goal, and that was the ECJ, previously mentioned. Joseph Weiler famously coined the dual character of supranationalism over the course of the 1960s and 1970s, and that integration came to be characterized by apparently paradoxical emergence of two conflicting trends: an expansive normative or judicial supranationalism on the one hand, and a much more constrained, if not diminished, decisional or political supranationalism on the other. So almost kind of going back to Montesquieu, the spirit of laws, and that there's separation between the judicial and in this time they use the word political, but the judicial and executive, the judicial and legislative branch, a necessary division of powers, which clearly makes sense. If it makes sense at the national level, clearly it must make sense at the European federal level. Lawyers and judges clearly played a major role in the development of the normative side of European supranationalism in the founding period, and viewed themselves in and around ECJ as the institutionalized carriers of the European idea in the face of political resistance and reluctance, and therefore were able to draw the perception as protector of individual rights against the state. And Article 177 of the Treaty of Rome provided for a mechanism for the option of national courts to refer questions on the interpretation of this treaty to the community's own supranational adjudicative body, the Court of Justice. So therefore, in the Constitution of the European Union, the Treaties of Rome, there's Article 177 sort of reverts back, giving power to the European Court of Justice. So a check and balance, kind of in the spirit of the beautiful American Constitution. And the cornerstone of this jurisprudence was the method of treaty interpretation, the teleological method, an ever closer union among peoples of Europe. And no judgment of ECJ from the founding period better demonstrates this approach than the Marbury v. Madison equivalent in EU law, previously mentioned Van Gend's on Loos judgment of 1963, in which the court recognized the de facto private party standing to bring claims of member state nonconformity with supranational law by way of a preliminary reference to the national court under Article 177. The Treaty of Rome did not provide the right tools for the court to pursue the purported preference of Europe, and therefore the case extended the scope of the community system of judicial remedies and laid the foundation for subsequent transformation of public law in European integration. So I think one of the key takeaways here is that European integration could not really have fully manifested itself without the judicial side. Moving to section 4, the last section of this wonderful chapter by Peter Lindseth. As Morten Rasmussen of Integration aptly put it, Van Gend's on Loos was a revolution in case law of ECJ and final endorsement of constitutional approach of European law. So it sort of kind of pulls upon the European Constitution, giving power to the European Court of Justice, and that it is celebrated has increasingly become an object of historical analysis and legal critique in recent decades, and criticism that it is not expanded. Democracy, however, also exists. The problem goes deeper than in the imperfect habits of governmental control, parliamentary accountability, and administrative responsibility, rather to an absence of a coherent European demos upon which to construct a genuinely constitutional bodies on the EU level. So although it sort of does take this constitutional approach, there is doubt of the power of the European Union Constitution itself. And it depends on an intertwined democratic and constitutional self-consciousness, on a sense of mutual entitlement and solidarity to make representative government possible. It is as if the EU possesses, according to the author, a robust form of legitimacy in its own right, in defiance of the EU's actual socio-historical character. Despite what EU judges, lawyers, and law professors have maintained since the founding of integration, there have proven to be numerous features of EU public law that are merely in tension with, but also directly contradict the dominant constitutionalist discourse. First and foremost, the EU remains almost entirely, according to the author, dependent on member states for a sine qua non of genuine constitutional power, and therefore legitimate compulsory capacity to extract and redirect, mobilize either fiscal resources through taxing and spending, or human resources through policing and defense for the benefit of the polity at whole. So its powers are limited and significantly still dependent on the nations. Secondly, even with regard to rulemaking and adjudicative power, the EU remains dependent on mechanisms of constitutional legitimacy of national institutions to the EU level. Mechanisms of constitutional legitimacy of national institutions to the EU level as well, and that mechanisms of mediated legitimacy drawing importantly on models developed in post-war administrative state, and therefore the central features of the institutional development of EU governments since its inception were set in place. And therefore, the shortfalls in the EU's legitimacy traced to the founding period of its integration from the 1950s and 1960s proved to have particular significance in the period of crisis since 2010, from the Eurozone issues to the influx of refugees and the increased terrorist threats in the European Union. The Italian political theorist Stefano Barolini says, "The risk of miscalculating the extent to which true legitimacy surrounds European institutions and their decisions may lead to overestimating of capacity of the EU to overcome major economic and security crises." So it has to be powerful enough to address these potential serious threats. The EU has been forced to rely on a strategy where all essential costs, political and economic, are borne internally by individual states because that is where legitimate coordination has been necessary. But the coordination primarily is national and intergovernmental rather than supranational. So that's also another thing. Intergovernmental is not the same as supranational in this context. So, for example, if something happens in France and Germany thinks of helping them, that is not at the EU level, that is intergovernmental. And it's not a commission and court, but a European Council or Eurogroup finance ministers who often address these. The primary exception is the European Central Bank, however, which seems to have pretty supranational power. Sometimes the heroic role is driven by the incapacity of the EU and member states to mobilize fiscal resources on a coordinated supranational scale, and is commensurate with the demands of the Eurozone crisis. The continued locus, according to the author, of true democratic and constitutional legitimacy at the national level have a direct bearing on the scope of the power that can be successfully transferred to EU institutions, a fact true of integration since its inception. Understanding how this power legitimacy nexus affects what the EU can realistically achieve, as well as how its laws should be interpreted, is not just a legal theoretical exercise, rather it is crucial to sustainability and success of European integration over the long term, something that European elites, particularly EU judges, lawyers, and legal scholars, ignore at their peril. So, very, very fascinating chapter by Peter Lindseth, and so many more things to look into deeper. For example, how has the United States history influenced the European integration? How does it vary across times, across different geographies? How did the specific institutions come into being, and how did they sometimes leave from existence? Many, many fascinating things going on here. So thank you, Peter Lindseth, for this fascinating chapter. So to the content of the slides, this chapter is in part 5, Illustrations, Doing Things with Legal History. This is chapter 54 of the Oxford Handbook of Legal History, titled Foundings, European Integration. And the author is Peter Lindseth. His position is the Olympiad S. Yoffe Professor of International and Comparative Law at the University of Connecticut. Suggested readings include Power and Legitimacy, Reconciling Europe and the Nation State, published by the Oxford University Press in 2010. Next book, Comparative Administrative Law, edited, where he's an editor with Rose Ackerman S., published by Edward Elgar Publishing in 2010. And the Administrative Law, and third book, Administrative Law and the European Union, Oversight, with Aman A., Raul A., Berman G. et al., published by ABA Publishing in 2008. The author's research interests include comparative public law, both administrative and constitutional, corporate and regulatory compliance, and European integration, and legal history generally. The two logos we have in the top right are Cornell University, where he received his Bachelor of Arts and Juris Doctor, and in the top left we have the University of Connecticut, where he currently works. I might have also added Columbia University in the middle, where he also received his PhD. However, for Norman Spaulding, I only had two put up, so I kept them parallel. As for the three quotes, first quote, "The catastrophe of 1933 to 1945, indeed 1914 to 1945, is rightly seen as a central impetus behind the founding of European integration in the 1950s. A crucial dimension of the founding, however, also relates to the advent of the modern administrative state in the 20th century Europe, what we may call the post-war constitutional settlement and administrative governance after 1945. Second and next quote, "Beyond the functional demands of post-war reconstruction, along with a desire to transcend excesses of nationalism, the post-war period was also the moment in Western European history when the constitutional foundations of modern administrative governance were also secure." Third and last quote, "In short, the continued locus of true democratic and constitutional legitimacy at the national level has had a direct bearing on the scope of power that could be successfully transferred to the EU institutions, a fact of true integration since its inception." So thank you again, Peter Lindseth, for a fascinating chapter. Thank you, Norman W. Spaulding, for your fascinating chapter as well. So in terms of the comparison in the style of Plutarch's Lives, to hopefully learn a little bit more about these two individuals and their respective works. So Norman W. Spaulding is the Nelson Bowman Schweitzer and Marie B. Schweitzer Professor of Law at Stanford Law School, and Peter Lindseth is the Olympiad S. EFA Professor of International and Comparative Law at the University of Connecticut. So they both have named professorships, which is certainly a similarity, whereas Norman W. Spaulding is more of a general professor of law, whereas Peter Lindseth is listed as a professor of international and comparative law. In terms of their degrees, they both have a Bachelor of Arts, as one might, Norman W. Spaulding did his at Williams College, which is a liberal arts college, which is a little bit different from Peter Lindseth, who did his Bachelor of Arts at Cornell University, which is a more traditional Ivy League institution. And Peter Lindseth also received his Juris Doctor from the same institution that he did his Bachelor of Arts at, which is Cornell University, whereas Norman W. Spaulding did his at a different institution, which was Stanford Law School. So it must also be noted that Norman Spaulding has studied in both New England and in California. But Peter Lindseth also has a PhD in European history from Columbia University. So Norman Spaulding actually does not have a PhD, although Juris Doctor is considered a doctorate degree by many. This is a difference in that they both have a Juris Doctor, both have a Bachelor of Arts, but Peter Lindseth does have a PhD as well from Columbia University. In terms of their interests, Norman W. Spaulding is interested in civil procedure and litigation, complex litigation, ethics and professional responsibility, federal courts and federal jurisdictions, and legal history, and particularly in this context, American legal history. Whereas Peter Lindseth is interested in comparative public law, both administrative and constitutional, corporate and regulatory compliance, European integration, and legal history, but I would also add European legal history. So that's one key difference there, is that Norman W. Spaulding is more focused on the American context, and Peter Lindseth is more focused on the European context. However, they both have interests in, and Norman Spaulding might be a little bit more interested in litigation, whereas Peter Lindseth might be a little bit more interested in perhaps public law or international law as well. But they both have an interest in administration. In terms of their positions, Norman W. Spaulding is also a member of the American Law Institute and the American Bar Association Standing Committee on Ethics and Professional Responsibility. And in 2004, he won the Association of American Law Schools Outstanding Scholarly Paper Prize for Constitution as a Counter-Movement, whereas Peter Lindseth also was a recipient of the 2012 Daimler Berlin Prize and a Fellow of the American Academy in Berlin. So both have won awards and both have affiliations and responsibilities outside of their formal academic work. However, Peter Lindseth's were in Europe, whereas Norman Spaulding's were in the United States. Peter Lindseth was also Associate Director of the European Legal Studies Center at Columbia Law School previously, whereas Norman Spaulding was a visiting professor at Harvard Law School and previous professor at UC Berkeley School of Law. So once again more connection to California and New England, whereas Peter Lindseth was a visiting professor at Princeton, Yale, Tilburg, Queen in the Netherlands, Queen Mary University of London, Paris 2, Panthéon-Assas, Paris 2 is Panthéon-Assas, and Marseille. So more in Europe. However, it doesn't seem like he has been to the West in the United States too much, and given the size of the United States, it almost is that's why I think it's nice that these go together, because there's quite a bit of differentiation within the United States as there is within Europe. Maybe not as much differentiation, but there is still lots to see in the United States. Peter Spaulding has also held fellowships and associateships at Oxford and NYU as well. In terms of their books, it seems Norman W. Spaulding has one full book, but many co-authorships and many book chapters, whereas Peter Lindseth is the author entirely of over 4 books, maybe 7 if we're including co-authorships as well. So Peter Lindseth probably has more books to his name, but we might add that Norman W. Spaulding has also a pretty significant period of his life where he was practicing, however, where he was an associate at Skadden Arps, Slate, Meaghan and Flom, LLP, which is one of the top corporate law firms, where he practiced environmental litigation. He also clerked for Judge Betty B. Fletcher of the U.S. Court of Appeals, Ninth Circuit, which covers District of Alaska, Arizona, Central, Eastern, Northern, and Southern California, Hawaii, Idaho, Montana, Nevada, Oregon, Eastern and Western Washington. He also clerked for Judge Thelton Henderson of the U.S. District Court of the Northern District of California. So he clerked both times in covering California, but also covering sort of western states. But the Ninth Circuit is supposedly a very exciting appellate court to clerk for, because it covers many geographies, but also particularly interesting ones. Like, there are a lot of fascinating cases coming out of Alaska. Whereas Peter Lindseth, I did not see any details about him practicing, but maybe he was during the time. Instead, he attained a PhD, for example. But I didn't see press work clerking as well. But instead, he did a PhD. So, and then I guess maybe one of the biggest takeaways is that, and I've already mentioned it before, but I haven't written here as well, is that Norman W. Spaulding is focused predominantly on the American experience, whereas Peter Lindseth is has certainly done much work in the United States, but he seems to have a particular focus on European experience. So, thank you very much, Norman W. Spaulding and Peter Lindseth, and thank you very much to you for watching and or listening to this video on Guide to Legal History and Historians, and I hope you enjoyed and continue to support. Thank you so much.